In contract law, courts may find that a contract is unconscionable and therefore unenforceable when the contract is oppressive or unreasonably favorable to one party. In determining whether a contract is unconscionable, courts consider two types of unconscionability. First, procedural unconscionability, which deals with how the contract was negotiated and the circumstances of the parties, including whether there was oppression or surprise. And second, substantive unconscionability, which deals with whether the contract terms were overly harsh or one-sided. In Capili versus the Finish Line, a federal district court in California considered whether an arbitration agreement in an employment contract was unconscionable and unenforceable. The Finish Line is a national athletic shoe and apparel retailer that is headquartered in Indiana. From June of 2010 to March of 2012, and then again from August of 2013 to July of 2014, Rita Rose Capili worked as a sales associate at a Finish Line store in California. Prior to her second stint at Finish Line, Capili was asked as part of her application to sign an agreement to arbitrate any and all future employment disputes between her and Finish Line. In fact, signing the agreement was a condition for Finish Line to even consider her application. Under the arbitration agreement was a forum selection clause naming Indiana as the place for arbitration. Also under the agreement was a clause exempting certain claims likely to be brought by an employer from arbitration, including claims for injunctive or equitable relief for unfair competition and the disclosure of confidential information or trade secrets. Further, there was a cost-sharing clause in which both parties had to share equally in the costs of the arbitrator. In July of 2014, Capili submitted a request for a leave of absence related to her pregnancy and other medical conditions. In response, Finish Line fired her. Subsequently, Capili sued Finish Line in United States District Court for the Northern District of California for unlawful termination. In response, Finish Line moved to compel arbitration.